Yep. Okay. Go!
Will you hand me my screen box?
Now go.
Stanford versus Norman.
Good morning, Your Honor. Jim Kurji, PA 320 on behalf of plaintiff, Gil Stanford.
Your name?
Susie Norman.
All right. And where are we on this case? Well, good.
So, Your Honor, I submitted a motion for summary disposition. And that there's no genuine issue back here on this non-payment.
Did you get a copy?
I did via email.
Are you going to respond to that?
I have my response was a case that I had opened. It's supposed to go under Judge Barr. That was my response. And I came to the courthouse and wanted to file what I could. And the girls said there was a note on my case that said, Judge Barr, I guess Judge Barr, I don't know. Someone wrote a note that you were going to look at that today and use that as my
Okay, great.
counter,
Well,
since the cases were of the same people.
have you vacated the premises or no?
I have not. As you know, I have my job offer in Seattle, and I'm here because I'm still here in the city because I have to appear in person. So, and just trying to wrap this up.
So in regard to your motion for summary, why wouldn't I consider what she has filed in the other case as creating a genuine issue of material fact?
So, Your Honor, one moment. The jumps to that case is that her property didn't have a certificate of occupancy. That was just brought to light recently as, I guess, a separate claim. Rent was ordered to be placed on escrow by the court. Rent has not been, only 1 month of 3 months rent has been placed on escrow with the court. In my motion.
Right, but if there's no certificate, if there's no COC, how does your client even charge rent?
So, Your Honor, my client has been in touch with the city of Pittsfield and has been arranging to get the COC.
The city of Ipsy?
Pittsfield Township.
Yeah, okay, that's fine. But how does he charge rent if he doesn't have a COC?
So, Your Honor, this is not a, we're not claiming rent. We're not claiming money damages for rent. We're just claiming for the possession.
I don't know what that means. This is not a claim for money damages. It's just a claim for return to property. At some point, some rent is due because Ms. Norman remains in possession of the property. But there's no COC.
Your Honor, the COC expired in March of this year. According to my client, the city of Pittsfield has told him they're shorthanded on building inspectors. That's why he didn't receive a notice. He's been in touch with them to try and get the COC sorted out. The number of things pointed out on the violations of the other case are things such as a permit for electrical outlets, permit for a water heater. There's no complaints in that inspection report of items that are not working. It's items that are not up to code.
Is there anything under the Pittsfield ordinance that extends it?
Say again.
Is there anything under the Pittsfield ordinance that extends the COC?
Not that I'm aware of,
There isn't.
but I have no control over them administering their duties as far as issuing those.
Do you have the prior COC?
I don't, but I don't have it on me, Your Honor. But it was issued in 22.
With CVO?
Yeah.
Right.
My might have it on.
Did you call to get an inspection?
I called the building department in regards to this matter. And they.
No, prior to March.
No, I did not, because I was not aware that this was about to expire. Normally that process is,
It's a 2-year certificate.
they send out letters saying,
Right, I understand that, but it's a 2-year certificate. So the question is, if she's paid rent through June,
Last payment was on 5/24. And I have a balance on the property of, to the best estimate, $19,845 in rent and $1,500 in water bills and other utilities.
19,000?
In rent due. Rent's $3,300. I have the last payment. So, Your Honor, we could go through with a 30-day notice, but my client has been undergoing efforts to obtain that COC. It's not as if he has just ignored the issue. He's made efforts to correct it, and he would like to correct it. The problem with correcting it right now is that Ms. Norman is in possession of the property, and he can't make repairs, or has attempted to make repairs and been told.
Has he attempted to make repairs?
That is,
I have tried to make repairs. There's been 4 times when I have set a appointment to go over there, make repairs, and she has refused me to enter to make those repairs. So I can't make the repairs.
When is the township going over?
What's that?
When is the township coming in to inspect?
Well, they are claiming they're going to come back in November 2nd or something.
Then counsel, if that's the case, why am I hearing this now? You have no legal theory upon which you can proceed. The other case is now my case, so I'm just going to consider it as a counter to this case. So why am I hearing it today if your client has no COC?
Your Honor, I heard it first at the last hearing, so I may have a moment to confer with my client. Thank you, Your Honor. We can agree to dismiss this at this time and move forward with under a different process as we try and as my client attempts to obtain a COC. The court feels that that's the best thing to do at this time.
I'm just trying to figure out how you're going to proceed. I think part of Ms. Norman's claim is that she's owed money.
So Ms. Norman has been in possession of the property the whole time under a lease agreement. Now that lease agreement has an issue with the COC.
She cannot legally do because he doesn't have a COC.
So without more investigation into the COC and why that wasn't issued or what the issues are with the COC, I can't speak to the matter at this time. I've looked at the inspection report that was provided in the other case, and the items on the inspection report didn't appear to be items that would be interfering with the daily use of the premises.
You do understand this isn't about habitability.
Correct, Your Honor. My client has, have you had some difficulty obtaining?
What's that?
You had some difficulty obtaining COC work?
It probably was.
Yeah.
Well, they made an inspection and made this report, and they have another inspection lined up for the November 2nd. But if she won't let me go in to make repairs, I told the building department, because we're in the middle of an eviction, that I want to delay that till she lets me in. Will you make an order to?
Your Honor, I think he's saying until he believed he would get possession back and then finish the permitting of the boiler and whatever was on the inspection report.
When are you going to let him in?
The problem with me letting him in, the first time, he comes over unannounced, and I've asked him not to do that. I've asked him to contact.
Okay, Ms.
me.
Norman, give me a date that you're gonna let him in.
He give you a date when he could come in and repair? Or when, I'm sorry, I didn't hear you. My bad.
Isn't that what I said?
Is that what he said?
Yes. That's what I said.
I don't have a problem with him coming in. I have a problem with him cornering me off, asking me when I'm getting out of there when this case is ongoing. He's done that twice. That's why I have a police report on my other case, because he just popped up unannounced, asking me when I'm gonna pay the rent, flashing the water bill. I talk to Cindy at the Pittsfield Township every time we have a court date, and he has me paying it. He's suing me for the water bill. I just let them know that I will, if whatever the ruling is, I will let them know if I have to pay it or if I have to pay him and he's gonna pay it. I don't have, so that's the only problem. He comes unannounced and he starts asking me when I'm paying the rent, when I'm putting stuff in escrow, when I'm doing this, when I'm doing that, and that makes me feel uncomfortable. So if he needs, and I know that the city has had, he said that they were backed up and couldn't come. I called them and they came for me to inspect it.
Okay. So I don't know why neither of you want to answer my question.
As I don't have a problem with him coming and doing his repairs, if that's what,
So what day can he come in?
whatever. I mean, he can give me a day. He's all over the, like, we've done this before and it's like, you have to ask him. I will make it.
Okay, so what day do you want to go do the repairs?
I cannot say that it's gonna be all in one day. There are several.
Okay, so what day do you want to start doing the repairs?
I will start, later this week. I will come in,
That,
Thursday or Friday. Either that,
Emily, if I said to you, give me a date for a case, would you just give me any date and just an approximation? No? Because that's not what I asked, right? Yeah. So.
all right.
Glad we got it straight, because I was trying to figure out if that's how it worked. Yes, you.
I will do the work next week. Between Monday and Friday, I will,
So what date are you gonna, geez, oh Pete? Just,
Monday.
what is Monday, Emily?
the 28th.
28th.
But I will also probably need to be in there other days. There's drywall repair that needs to be done. That cannot be done in one trip. I need to have inspectors lined up and scheduled to come in for their process. And I don't know what their schedule is and when I can get an inspection for them. It's not a one-day repair to get these things done.
Oh, no, I've seen the pictures. I realized it was gonna be more than a day. So you're gonna go in, start repairs on the 28th? Question mark, right?
Monday, the 28th. I will plan on going in and doing all the repairs I can that day. There will be other issues that still need to be addressed
You guys.
with the building department.
Okay. When are you leaving? That was also a question.
I am leaving as soon as I don't have to come back to court anymore. I mean, can we do it in Zoom, Seattle? I just can't move from there to another spot and then to Seattle. The only reason I'm still here is because this case is still going. And the reason I'm here is
Okay.
seeing the pictures.
So
I mean, is this case gonna be done after today? Is it gonna be completed, finished?
at the rate you guys are going? Really? Okay, so here's what I'm gonna suggest. Can you guys talk to each other civilly? Without me?
I
Don't think so.
certainly think I can.
Your Honor, this case involved itself with possession.
What?
Case resolves itself with the should Ms. Norman be moving to or going to Seattle?
Except council. You're charging rent. You just told me it was 19,000 that you want from her.
Your Honor, what we want is possession. We haven't claimed, there's been no claim for money judgment.
So you're gonna waive rent?
No.
Okay.
Well, in this case, we're not asking for rent.
Wait,
We're-
Your Honor, my client agrees to waive rent.
Okay, well, would you agree to release the escrow to me so he can get possession? I can go and the case can be done today.
Wow.
As much as I like to be in this courtroom, this is my eighth.
Oh, I liked it until this morning.
What?
Look, here's what we're gonna do. You're waiving rent. You're waiving any claim for monetary damages.
Yeah,
Is that right?
yes.
And when are you gonna leave?
10 days? Or less?
Perfect.
Mr. Courage, you said perfect. I'm not trying to stress you out, Judge.
You are not stressing me out.
Okay,
Trust
good,
me.
Good.
Trust me. I got a lot more. I got a lot of
Okay.
other things that stress me out.
All
This is not one of them.
Oh. There's the bright spot.
Okay, so what are we doing? You waived your claim for rent. You're moving when?
10 days. Or less, and I can take the key.
Jeez, so Pete, give me a date. Just give me a date that you're going to leave.
What is the date today? The 22nd? October 31st.
It was the 22nd. It's probably the
October
25th by now.
October 30th.
What? October 30th. Will that work?
That worked, Your Honor.
Do I need to get this repairs done next week? Or that's, can be done after she moves out?
Write up a conditional order of dismissal, waiving all claims for rent money. You can put both case numbers on it because if there's no claims for money, then that would resolve your other case, would it not? Amazing how I do this. Write up a conditional order of dismissal, look it over. She's going to leave on the 30th. And then come back and I'll sign it. All right. I'll pass the matter so you can write that up
All right, thank you.
Come back and
today. Oh, no, you guys are not leaving.
in escrow.
What about it?
I'd like to have that.
Okay. If they've waived all claims for money, what do you think happens to escrow?
I don't assume anything. In nursing, we don't assume it. I can't assume it in your courtroom, sir. As long as it's written on the conditional dismissal, then fine. Can't assume anything. I don't know the law language. I don't know it.
Oh, I'm
Yeah,
aware.
I know.
I'm aware.
The 8 times I've been here.
What?
I said, I know you probably gathered that the 8 times I've been here.
It's only been 8. Seems like 50. All right. Go out, write that up. Escrow goes back to defendant, plaintiff on the other case, and then we can be done with this.
All right, thank you, Your Honor.
Thank you. Hey, do me a favor. Keep an eye on them because that's going to blow up. I don't know what's going to happen, but it's going to blow up. I want to call another one. I know. It's going to go better. Well, Stanford versus Norman, Norman versus Stanford. Darrell, do we have a conditional order dismissal? All right. Okay, this is fine, except that, how much is the water bill?
I know that it's at least 1,100. The last bill that came
It
out.
was 1,500. It was 1,500 when I walked in.
It's 1,100. It's 1,100. And because of the leaks in the house, I'm having that evaluated. But That's how much it is now, because they bill every 3 months.
So when's the next billing?
Well, the billing is, I know, I'm not sure it's set up on quarterly. I believe it is. I'm not exactly sure.
You got the bill and came over and waved it in my face. You should know.
Was that really necessary? Was it necessary?
No,
Was it necessary?
no.
Then don't let it happen again.
This one was a due date of 10/2. It was $1,058.17. And it is every 2 months.
You're agreeing to pay the water bill, whatever it is, to the 31st. You can call the water company and you can get it so that the 31st is a date they can tell you how much you owe.
Okay, Your Honor. Thank you.
So here's what I'm going to do. I will release the escrow to the defendant, but I really don't want you guys back. So I'm going to hold the escrow until I can get a final water bill. Then pay the water bill to the plaintiff. The balance will be returned to the defendant.
Thank you, Your Honor.
I don't understand.
Okay. Let's say the water bill comes up by the end of this month being $1,500. Okay, that's what I heard. All right. Let's say it's $1,500. They will get to me that final water bill. Right. And then what I would do is I would send them the $1,500 as though you're paying it, and then release the rest of the escrow to you.
Okay, we have to wait till the 30th. Yep. I have to
Till
get
you
the bill
move.
for the 31st.
Pardon?
I have to get the bill through the 31st or through now. And you just take the money out of that and pay that bill. That was due on 10/2. They're not gonna have a final meter read because they want to change the meter anyway. It's from 1998.
You need a reading as of the 31st. Whatever that reading is, the water company will go through, they'll figure out what's owed through the 31st of October. That amount will be deducted from the escrow and will go to the plaintiff, right, to Mr. Stanford. The remaining part of that escrow will then be paid to you. Anybody unclear as to that?
Makes sense to me.
I'm clear, but
But what?
I don't think they just, never mind.
You don't think they just what?
Never mind. They must read it at the building.
We'll call them.
Get a final reading as of the 31st. Otherwise, what's going to happen is I'm going to just wait till the next bill comes out in 2 months. I'll prorate it myself.
Here. Fix that water.
I'm just going to add to this that the escrow is to be released after presentation of final water bill. So what I'm going to do, folks, is this. This resolves this case. And what I have here is that plaintiff is waiving any claim for rent. Defendant agrees to return possession to the plaintiff on or before October 31st, 2024. Escrows to be released to the defendant. The defendant, however, agrees to pay the water bill through October 31st, 2024. I've added language that escrows will be released after presentation of final water bill to the court. Does everybody understand that?
Yes, but I could use that escrow for moving.
Yes.
I have 5 people to move.
Okay, so you don't want to agree to that? When is the water bill going to be paid then?
Pay it out of the escrow, that'll, of 1058. That'll take care of what's due now. That was due on the 2nd.
Then what do we do with the period from that 2nd through the 31st? You realize, ma'am, that water bill becomes a lien on the premises if it's not paid.
I do.
Okay, so it's somehow or another, it's going to need to be paid.
That last portion I will pay. That last portion from the 2nd to the 31st.
You guys figure out what you want to do because the money's there. I told them to get a bill. You don't want to do it that way. I can't sign this conditional order dismissal. I don't know why you two can't come to some type of rational understanding of how this is going to be done. If you guys want to sit in here all day and fight it out, fight it out. Court's in recess.
All right. District Court for County of Western State of Michigan is now back in session. The Honorable Judge J. Cedric Central presiding.
You may be seated. You guys work out. Let's try it again for the 3rd time. Stanford versus Norman.
Ms. Norman and I have, we've come to a clarification on the consent order. Plaintiff is going to waive any claim to rent. Defendant agrees to return possession on or before the 31st of October, 2024. Plaintiff and defendant agreed to split the $3,300 escrow in the following way. Plaintiff is to receive $1,500, the defendant is to receive $1,800.
Plaintiff gets $1,500.
Defendant shall receive $1,800.
Did you write that up? Ms. Norman, is this your understanding?
Yes, it is.
Do you have any questions regarding anything contained on this conditional order dismissal?
I don't have any questions regarding that. I do feel like I'll be back to see though. For
Why?
damages, but
Your damages.
yeah. But
Underlying which in,
I understand that and I signed it and there it is.
well, but that's going to get rid of this case also. That's why I had you put both case numbers on. I was trying to resolve all these cases. So is that your understanding, ma'am?
Yes.
Just going to add a provision on here that case ending in 3728 is dismissed as part of this. Do you have any other questions regarding anything contained on this? All right, you do have 3 business days to think about this. If you have any, if there's any legal reason, any misunderstanding, any non-assertion of rights in this matter, you'd have to file a motion with the court. That doesn't mean that I would grant the motion. However, you do have those 3 business days. You understand that, ma'am?
I do.
Case ending in 2445 is conditionally dismissed, and I've signed the order. You can pick up a copy up front. The other matter is dismissed. Thank you.
Thank you, Your Honor. Good morning.
River Ridge versus Timothy Kelly.
Morning, Your Honor.
My goodness. Take your appearances, please.
Rachel Dornbush, Palace Law, 7301 on behalf of plaintiff.
Your name, sir?
I'm Tim Kelly, yes.
All right.
Sorry, Your Honor.
No, not a problem. Ms. Dornbush, you guys can have a seat. Okay, so where are we on this case?
Your Honor, I think today is the date and time for, I think, a settlement conference.
Yes.
As of the last date, Your Honor, given plaintiff an opportunity to file a reply to Mr. Kelly's answer, which got done, setting forth deficiencies in the answer, what I would call admissions in his answer, citing additional grounds on which the plaintiff has to terminate Mr. Kelly's safety. The most serious of which, Your Honor, is based on the revocation of Mr. Kelly's driver's license, which I believe occurred in 2022, and he's certainly been driving his car in the community over the last 2 years, and that violates Michigan statute and the lease and rules and regulations clearly state that a violation of Michigan statute or any other ordinance, local, state, or federal, is grounds for termination of the tenancy. So I don't know that there's a tribal issue in this case, Your Honor. For that reason, we would be asking for a judgment possession today.
Mr. Fields.
I can't hear a word she's saying. I'm sorry, Your Honor. Like 40% hearing, trying to get a hearing aid right now. Appreciate it. Sorry. Like this?
No.
Like this.
Yes.
Got it. Sorry. That's much better. Thank you.
I was going to have you do it the other way. Sit here and laugh. Anyway, all right. Could you briefly surmise what you just said, Mr.
Yes, Your Honor.
Sorry.
And for that reason, I don't believe there's a tribal fact here. I do believe plaintiff is entitled to a judgment possession.
Your response, Mr. Kelly.
Your Honor, none of that was brought up in the initial complaint back in July. I mean, so she hasn't brought up one thing that the original complaint stated. So, you know, I don't know where the laws come in as far as my license and everything, but
Pardon?
I say I don't know where the laws lie as far as I haven't researched anything in the Michigan state statute or the community guidelines that mentions anything about driver's license. No, that's because this is the first I've been accused of that. I mean, it's all the first time it was brought up, and that recently happened, and I don't have to own my car anymore. So
What recently happened?
that my car was taken away or impounded, not impounded, repo.
Your Honor,
Go ahead, I'm sorry.
if I may reply to that. Your Honor, our reply to defendant's answer does set forth the ongoing grounds listed in the original demand for possession, which Mr. Kelly failed to respond to several of those. In his answer, Your Honor, very vague responses to the complaint for possession, 1. 2, Mr. Kelly does not respond to the claims that he was parking on the lawn, that he's been disturbing other residents, and that he has verbally abused the threat management and their personnel. He doesn't respond to that at all in the complaint, or in his answer. He makes no statement in support of his claim of retaliatory eviction. The original demand for possession, Your Honor, does state that we would rely on those being specifically delineated, but it also indicates that it would rely on any other violations that it becomes aware of at the time that this demand was issued. The plaintiff was unaware of some ongoing issues with Mr. Kelly not having a driver's license. And so now the plaintiff is aware of those, they are going to be relied upon in this case.
I did respond to those as calling them false. I mean, there isn't one statement there. I didn't know if that should have been brought up with my answer or brought up in the trial. Negate those accusations properly, because they don't stand up to the truth. None of them. So I did state that in the answer.
Your Honor, the Michigan Court Rules MCR 2.111A require a clear and concise answer. The same rule, subsection D, requires the defendant to state the substance of the matter he's going to rely upon in defending a complaint filed against him. 2.111F requires defenses to be pleaded. It also indicates that allegations that aren't addressed are deemed as admitted. Because Mr. Kelly did not specifically, he doesn't make any specific statements at all regarding the claims against him. Again, a vague assertion that they're false, but how are they false? There is nothing in his answer to support his claim that these allegations are false.
I did go through each step that they were claiming and disagreed with them. I mean, I thought that's what the answer was supposed to be as far as the state guidelines and the community guidelines. I didn't know I had to Each one, I thought that would be brought up in trial when I could bring evidence.
No, sir. That's not how it works.
If I just answered that these aren't true, each one, where's that get us? I mean, I don't.
Well, you have to specifically lay out what your answer is, not just some general denial of everything.
I don't see anything true about it. It's, it's under the guise of, upon information and belief, which is, it's just hearsay when the bottom line. So I didn't, I don't have a lawyer. I can't even afford a lawyer. So I'm trying to do it myself, Your Honor. But all that, I have phone numbers and all kinds of things that you can call if you want to verify my reputation as a decent human being.
When did you stop driving? How long has it been since you haven't driven a vehicle?
I'm getting my license back through the state for quite a while. I don't have any means to get to one.
So you haven't been driving for how long?
It's probably 2017.
So you've not driven a vehicle since that time?
Take the fifth on that.
Okay.
Well, I mean, I got pulled over I went to Bush's. It was for an emergency. I have a daughter at home. Stays with me off and on. And as far as that goes,
Got pulled over in Saline. Yeah.
I was driving that day just to go to Bush's
In August.
to get groceries. Yeah.
In August, right?
Yes, in August. I'm a senior citizen on a fixed income, and it's very hard to. Everybody wants lawyers or money, and I just don't have it.
You really haven't stated anything here. You say that they're retaliating. You've not stated anything regarding a retaliatory eviction.
Well, the reason I didn't, Your Honor, was because I thought that would be brought up in trial. I'd be happy to.
No, sir.
Well, okay, I could talk about it now. I mean,
That's not how this works, Mr. Kelly.
What do you want me to go through each one, even though they're false claims? I mean, I don't know how to do anything else except deny that what they're saying is not true. And the retaliation came the day after Ms. Smith and I got into a little scuff on the phone. And the next day I have a big thing on my door saying that I'm gonna be evicted. There's false allegations there that I can very easily prove wrong. One, I've never ever threatened an employee or her in any way,
Mr. Kelly,
shape, or fashion.
Mr. Kelly.
Yes.
If I set this for a trial and you lose, you're out in 10 days. You know
I'm
that.
out in 10 days anyway, from what I understand.
What?
If I defaulted or you judge for the plaintiff or side with the plaintiff, I thought I only had 10 days anyway. What? Is that true?
Yeah, it's 10 days under the statute.
Well, that's another reason that I feel I have to take it to trial. I mean, my outside of my house is perfect, but the inside needs a little work. And if I was going to sell it, I'd take a huge loss on that. If I had to get out in 10 days, find somewhere to live. I have a dog there. I've been there since 2017, Your Honor. This is the third corporation that's owned it or managed it. I wasn't written up once in those first.
Mr. Kelly, what do you want to do? They don't want you there.
I want to save my house. I want to stay there. I mean, I retired. I put everything I had into that house. I paid my life savings to buy that free and clear so I wouldn't have a mortgage payment. I mean, I was planning on dying in Saline, I mean, there. And it's in a trust. It's in a trust beneficiary, Your Honor, for my daughter. It's the only thing I have to leave for her. She's a disabled minority. She doesn't have anything that's going to be left to her except accept that house, and that's my plan, is to leave it to her. And I don't know, between Pamela and I, we used to get along great. I mean, I haven't been able to even speak to her, so I just don't, I'm kind of confused as to, she knows my situation. She knows my daughter. She's fed my dog when my dog comes up. We had a good relationship, and all of a sudden she doesn't even want to talk about it. So I mean, I feel that it's off the extreme. I mean, I cut the lawn for 4 older women there, and then I have everyone around me.
Mr. Kelly,
I just think I'm not the type of man that they're making me out to be, Your Honor. How else can I come here and
well, your pleadings are bad. And I could frankly find that I don't have a tribal issue and grant them a judgment today.
Sorry, Your Honor, could you repeat that? I didn't hear you, I'm sorry.
Your pleadings and your filings are bad. They're missing all kinds of things. It doesn't present to me an issue that I could even try at this point.
Well, I can't even keep up with the paperwork between the the monetary things that I get every month. I mean, I've been going to court. I've been before you for the last 6 months. I mean, it's hard to keep up with all their paperwork. I apologize, but I didn't know that, I can't afford a lawyer. I'm trying to do the best I can. I thought that I could, I can bring you evidence of negating some of that stuff in trial. I didn't, if you want me to answer that and give you
I told you to answer before, and I don't have it. Actually, I told you, I think, twice.
Oh, you do have it, Your Honor, because you found it at the last hearing. We took a recess because you didn't have it, but then the court clerk.
That's not what I'm talking about.
Oh, I'm sorry.
Your answer is wholly deficient.
Okay, I apologize. I was up all night. I don't know, really. I'm not an attorney, so I thought by just telling you that, I don't know how to answer. Some of those aren't accurate to the facts, so I didn't know if you wanted me to just state without any evidence to negate their claims. I didn't think you needed me to just say, what went on there, because I couldn't bring you any proof of it. So I didn't know that. I can present evidence and all of that if you give me time.
What would you present to this court, Mr. Kelly?
Well, I could present the fact that the claims that that they filed are false. For instance, the car on the lawn, the threatening of the employees. I don't have all of them in front of me, but I could prove that those aren't true. And there's been other write-ups that through the.
Suppose you have a photo.
We do have a photo. It's his mother-in-law's car. It was towed last year after many months and notices that the car needed to be removed. My understanding, Mr. Kelly, please let me finish, is that when the tow company came out to remove it, he threatened the tow company. Now, I'm still trying
That's
to.
a lie. That is a lie, and I can prove it wrong because I spoke to the Mayflower towing guy, and he denied that he ever said that. In fact, Ms. Smith said that he told her that he told her that I pulled the gun. Yeah, what is this? The car? I'm not denying the car. I'm denying that the fact what it said.
Mr. Kelly, you just
gave me permission, Your Honor, for that car to be on the grass. She knew that it was my ex-wife's mother's car, and she just passed away, and she didn't have anywhere to put it. And I had it on my driveway, leaking a little oil, so I just moved it. So I repaired that lawn, and it's a beautiful looking car if you saw it, but she was aware of it. Now, there was some controversy the day that it got towed because I was asking her to please wait because my ex had called me and she called.
If she gave you permission, why would they have it towed?
Because it took.
Why would they have it towed?
Because
If what you said, Mr. Kelly, if it's true, that they gave you permission to have it there, why would they have it towed?
It was, Your Honor, I could prove that it was.
See, that answer my question.
It was towed because it had come to the point where it was on the lawn, it was there too long. And she said that she stamped the car was there for a year, Your Honor, on that lawn for a year. And then she put a tag on the car, and that's when we started negotiating, and I called my ex and told her, you got to get this car out of here. They want it out and it's going to be towed. That was when it came to that point.
Mr. Kelly.
But it was on the lawn
Mr.
for
Kelly.
a year, Your Honor.
Mr. Kelly.
Yes.
You told me 3 different things about this car. You're telling me that they gave you permission to have it on there.
Yes.
So how long, presuming they gave you permission, how long were they allowing you to keep it on the property?
There wasn't any set time. It was there. I kept the lawn. I always whipped around the car. I cut the lawn. When the car was
I
gone,
didn't ask you about the lawn.
I repaired the lawn.
I didn't ask you about the lawn.
There wasn't anything in writing or set. It just came to the point where it was there too long. Like I said, Pam and I got along fine. And then it was getting to the point, look, that car has been on there, or the car has been sitting there for too long. It didn't have proper plates. And that's when they put a tag on it and they gave me 10 days to get it out of there.
And did you?
I was my ex-wife. Yes, she was in the process of getting it. And I was on. I had no.
You talk in so many circles, Mr. Kelly.
I'm not talking in circles.
You absolutely are.
You're asking me what happened, and I'm telling you.
I didn't ask you what happened. I'm asking very specific questions, and you're not answering.
I'm telling you.
You take off going in another
I
direction.
didn't have anywhere to put.
Why do I care whether you weed whipped around the car?
I guess you don't.
I don't. I didn't ask you that.
Well, they're making it out like my property's a junk pile, and it isn't. It's one of the nicest kept up yards in the area.
Did I ask you that?
I'm sorry.
First off, there's nothing in any of our pleadings in any way, shape, or form alleging that his site looks like a junk pile. So no, that is absolutely false. Your Honor, I have here a rule violation issued December 30th, 2022, no parking on the lawn. A rule violation issued on January 12th, 2023, no parking on the lawn. There's a note that they also emailed him about the dog being outside on coyote, also a violation of the rules and regulations, and the vehicle being on the lawn. On 2/1, he called and said he will remove the car within 1 week. On 2/16, the car was tagged. I don't know the exact date that it was towed offhand, Your Honor, but April 23rd, Your Honor. So many months after all of this. So Mr. Kelly had ample time to remove the car, and he didn't.
My ex was speaking with Miss Smith, and it was kind of between them at that point.
No.
I'm talking about the last. You can ask her. My ex talked to her. They were
Mr. Kelly.
They were talking
Mr.
back
Kelly.
and forth. Her mother died here.
Mr. Kelly.
Yes.
They told you to get the car off the lawn. They told you were in violation.
And I
You
did.
did nothing.
I did get it. It was towed.
Who towed it?
Mayflower Towing.
Okay.
At that point, I said,
Bad question.
I said,
You want to know what?
I was trying to save
This
my
is why-
ex some money.
This is, Mr. Kelly,
Yes.
you're never going to overtalk me.
I'm not trying.
No, you are.
Just seems like just a man trying to save my house, Your Honor.
Mr. Kelly, you told me about that vehicle. I just take that. What they told me is what Ms. Dornbush laid out. You weren't telling me the truth.
I am telling you the truth.
No, you're not. Why would she give you permission to park on the lawn and then send you a notice that you're in violation?
Because Honor, I can give you proof of when the car was there and when it was towed.
Listen to my question.
It was over.
Listen to my question.
Go ahead.
Oh, no. Mr. Kelly, you better check that attitude right now. You better check it.
I'm not trying.
You better check it, Mr. Kelly. Oh, don't. Oh, no.
I don't know
Oh,
what
no.
I'm doing wrong.
Here's one thing that you've done wrong.
Please tell me.
Here's one thing that you've done wrong.
What?
I am not gonna have that attitude coming from
I
you.
don't.
You need to figure out what you're doing. You have interrupted me throughout these entire proceedings. I'm not gonna have it. Outside of the fact you've got a warrant for your arrest.
I apologize.
You got a warrant.
I didn't know that.
Yeah, it's from the driving while license suspended.
I didn't.
So here's what we're gonna do.
Sorry.
Just so happens the judge is in front of his next door. But right now, you're gonna go into custody. We're gonna take you in. I'm gonna go next door, talk to Judge Freshour, see what she wants me to do with you.
Please, Your Honor, I have a gun. I need to wait.
What did I just say?
I just checked with the court about a warrant.
Court's gonna stay in a brief recess. I'll be right back. River Ridge versus Kelly. I had to check with Judge Freshour. We will be releasing Mr. Kelly not until 1 o'clock today. I'm not going to hold you guys here. What I will do is I'll set this, Ms. Dornbush, if you're available for a non-jury trial on the 30th. Will that work? Just doing that so you have to come back and see us.
Your Honor, we don't mind coming back at 1 if Your Honor wants to do that, but I mean, if it's for the purpose of doing a bench trial, we don't have all of our witnesses that we.
Right, and I think I'm gonna do a bench trial, let him bring what he wants in.
Should
Do
get
that.
our witnesses
All
together.
right,
So the,
October 30th, 2024 at 9.
Are you kidding me?
Oh my God.
You have got to be kidding me. What? What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're gonna start bringing people in person. People gonna learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
I have no patience for that. And trust me, after today, I'm sitting up here, I'm the one that needs a drink.